This program is brought to you by Emory University.
My name is Lisa Chang, and for the past 4 years I was county attorney with DeKalb County. I too want to thank the Thrower family for their past and ongoing support of the symposium. Since Professor McGovern mentioned water wars, I'm going to give a shout out in particular to Patricia Thrower-Barmeyer, who rendered fantastic service to DeKalb County and other local jurisdictions with respect to our own local water wars. I want to thank the Thrower family and the Emory Law Journal for this year's topic. As county attorney, it wasn't on a daily basis, but probably on a weekly basis that we dealt with issues of privatization, so this is very timely and informative. As people have alluded, there are certain incentives in government, and I was in government for the past 4 years, so I don't have an amusing framework for you, as Professor Terrell did. We're just going to jump right into it. We're very fortunate to have 3 noted professors who work in this arena. We are going to hear first from Professor Royne, who's going to discuss to what extent privatization is a new phenomenon. Then Professor Green will tell us about issues associated with privatization arising in the area of charter schools and education. Finally, Professor Wallach will discuss issues arising in the area of privatizing prisons. In order to keep the presentations flowing, I'm going to introduce the speakers now. Professor Royne is the Seymour Lugan Professor of Law at the University of Chicago Law School. She's a graduate of Yale Law School. After a clerkship with Judge Wald on the Court of Appeals for the DC Circuit, and several years of private practice in the area of taxation, she entered the academic world. Her scholarship focuses on both taxation and local government issues. Professor Green has a joint appointment. He is Professor of Education and Law with the Penn State Dickinson School of Law, and he is the Harry L. Bachelet II Chair of Educational Administration with the Penn State College of Education. This two-pronged approach to his career started early, as he is a graduate of both Columbia Law School and Teachers College. It probably comes as no surprise that his scholarship focuses on the area of education. Finally, Professor Wallach is an assistant professor here at Emory Law School. He has both a JD and a PhD in economics from Harvard University. Professor Wallach clerked for Judge Kaczynski on the Court of Appeals for the Ninth Circuit and Justices O'Connor and Alito on the United States Supreme Court. His areas of scholarship include law and economics, administrative law, and privatization. All 3 professors have extensive list of publications, which I decided not to go through so we could hear more of their commentary today. And with that, I will turn the podium over to Professor Royne.
Thank you, and thanks to the members of the Emory Law Journal, and particularly to Jessie Brown and her crew who have done so much work to put this symposium together, and also to the Thrower family for financing this symposium. And I just wanted to add that since I am actually a tax lawyer, it was really nice to hear all those wonderful things about Randolph Thrower, who was himself a tax lawyer. You don't usually hear nice things about tax lawyers. So I want to begin the presentation by stressing a point that was made by Judge Kaczynski earlier, and that is that governments have always had to choose between providing things themselves and hiring private entities to provide things for the government. There's always been a lot of outsourcing by government. I mean, when was the last time you heard of government employees actually building a road as opposed to hiring a construction company to build the road? And indeed, many of the things that are currently being outsourced are things that the governments have always turned to private providers to provide in one form or another. What's different is that in some cases, the terms under which these outsourcing arrangements are being provided have changed. Instead of looking to private providers in order to provide just particular goods, particular services, particular items like school buildings or toll roads or parking meters, for example. What has happened is that the government is instead leasing out, instead of contracting out for the provision of the item, they've entered into long-term arrangements for the provision of the function that goes along with the item. So the government, instead of entering into a construction contract for a toll road, just simply leases out the entire toll road function and leaves up to the private party not just the responsibility of constructing the toll road, but also of running the toll road after it has been constructed. Now, I happen to think that all too often this leasing out is not about underperforming public assets or public functions. Much of it is really about budgetary smoke and mirrors. These deals are a combination of taking out secured debt without mentioning that they're taking out secured debt, and the acceleration of either tax or fee revenues. A lot of it's just about moving things off budget, sort of the Enronization of government finance. But we're all sort of complicit in doing that, in trying to move things off budget. And as long as we remain complicit in doing that, what we've got to deal with is the question of how we can do that without destroying the services and the functions that governments have provided up till now. The way that it is done, or the way these arrangements work right now, is that in these leasing contracts, the private party is required to meet certain performance standards that have been worked out between the parties to the contract, governments and the private investors. But the problem is that many of these contracts have run for exceedingly long terms. The Chicago Skyway contract, for example, lasts for 75 years. The parking meter contract, by contrast, only lasts for 70 years. And as should be obvious to anyone with any common sense, performance standards that have been worked out today may bear little, if any, resemblance to the performance standards that one might think adequate for running a toll road or a parking meter system 20 years from now, 30 years from now, let alone 75 years from now. Circumstances change. If you think about roads, merely the development of electric cars may have certain, which may have different infrastructure needs than gasoline-powered cars. To say nothing of the advent of driverless cars, which are apparently going to come about and be on the roads well before the end of the 75-year lease is up, might cause, well, one to wish that there were different performance requirements in the contract than currently exist. And those are just the performance issues that I can think of now. With the 20 years from now, I might have a whole different set of performance criteria that I might worry about and want to have in the contract. In addition to the fact that circumstances change, there's the teach to the test phenomenon. That is, we've got performance metrics that are in contracts because they seem to us to be the relevant performance metrics, but over time it often happens that those performance metrics, it turns out, can only be achieved or can be achieved cheaper if one ignores other performance metrics that we didn't even realize were important because, well, we were achieving them and didn't realize that they were at risk. And again, under the contracts that are currently being written, there, generally speaking, is no provision for reforming the performance metrics, even though these contracts go for an extended period of time. So the question is, what can we do about this? What should we be doing about this? And one possibility, of course, would be to say, oh, gee, you can't have contracts that last more than a certain number of years. Put a limit on the time period for which contractual provisions can exist. Little loath to say that that's the right answer. I'm a little loath to say that that's the right answer because maybe there are some circumstances where it makes absolute sense to have contracts that last for a very long period of time. However, there is, something that is somewhat short of an outright bar on long-term contracts that might be helpful. And that comes from that something is something that already exists for federal procurement contracts and also for some state procurement contracts. Lease arrangements, generally speaking, don't count as procurement contracts. And that is the so-called termination for convenience requirement. Under federal procurement law, a contract with the government can be terminated by the government for convenience, which means you don't have to prove that the other party isn't living up to their obligations under the contract. And the damages that are payable are only reliance damages, not expectation damages. And as we all know, because we've all taken contracts at some point or another, reliance damages tend to be, at least in actuality, less than expectation damages. So my thought was that, well, gee, if we want to have these contracts and we want to preserve some level of public control over the performance of functions that are covered by these contracts, that we might want to have a non-waivable termination for convenience clause required to be included in each and every one of these contracts. It's hardly, such a contract provision is hardly a panacea. I can tell you right now that, gee, well, this is a Coasian situation. What you might find is that private parties, knowing that they're subject to termination for convenience, might just raise the price of entering into all of these contracts, and that would be bad for governments, although you might also say that's not so bad for governments because maybe it's a way of bringing home to them what the real costs of having one of these contracts are, or is, rather. And, of course, it's also true that figuring out the reliance damages in some of these contracts is, well, let's just say it's not going to be easy. Take the parking meter contract that the city of Chicago entered into for 70 years. The private party not only bought the actual parking meter machines, but they also provided the city of Chicago with a substantial slug of money, like $1 billion, well, $1.25 billion, I think it was, trying to figure out how much of that initial investment is amortized over time. And therefore, the unamortized portion that should constitute the reliance should the city want to get out of the contract is not going to be easy. Then again, perhaps if there was a non-waivable termination for convenience clause in the contract, the parties would be encouraged to specify what reliance damages would be up front in the contract, which also wouldn't be such a bad idea. So basically, my idea is simply that if we want to have some continuing public control over the performance of functions, it's not such a bad idea to make sure that there really can be an updating of that public control over time, an updating that doesn't necessarily leave the investors in a much worse position than they would have been in had they never entered into the contract. We don't necessarily want to say that these contracts shouldn't be entered into, but they should also leave the government with, well, something short of negotiating with the private investors over the expected profits over the next 60 years of this unexecuted contract.
Greetings. I'm very happy to be here. I want to thank the Throwers and also Emory for giving me a chance to come here to talk about charter schools and privatization. Looking over the biography of Mr. Thrower, it's very apparent that he was really concerned about issues of opportunity for both minorities and also for women. And so I do feel honored about that. I should tell you that my research has really focused on two things. One is choice, issues, the legal and policy matters pertaining to choice, and also to equal educational opportunity. And so charter schools seem to be a great way of meshing both of those foci in terms of what I study. And charter schools are basically seen as public schools that are created through a charter between the creators of that charter and an authorizing entity, usually a school district. And charters are given a great deal of freedom or autonomy from state rules and regulations. And in exchange for that freedom, they are expected to be more accountable. That is, that in the course of 3 to 5 years, they have to meet the educational goals set in that charter, and if they fail to meet those goals, then they can run the risk of losing the charter. Now, as of now, there are charter school laws in 42 states and the District of Columbia. They are like 5,000 charter schools serving 1.5 million students. And it's certainly been a big focus of the Obama administration with respect to the Race to the Top innovation, which billions of dollars are given to state legislators to develop goals that would include charter schools to improve educational opportunity for students, especially disadvantaged students. So one issue that I have been researching over the last 15 years on charter schools is the issue of there's a conflict between the goal of choice and equal educational opportunity. And the idea about choice is that if you have more choice, then there will be much more pressure that will be placed that will, in the end, improve the education of the entire system. But on the other hand, you have to consider that at times the ideas of choice and opportunity can come into conflict. And that is that, and this especially comes with respect to African Americans in charter schools. As you look at the data, you notice that more and more African Americans are supportive of vouchers and of charter schools. And I can count this African American among them. People ask me, am I pro or anti-charter? And I always joke that I'm a charter agnostic. That is that, just to tell you, I used to, among other things, I was on a quasi-judicial board in the state of Pennsylvania for 4 years, where we actually examined appeals of charters and actually voted to uphold several charters. So I always say, I'm obviously not an enemy. I voted for a few of them. So, but, I honestly thought that charters at first, in some of my early writings, I could see them as an opportunity to provide choice for African Americans, especially because they would actually create educational opportunities that they were not receiving in traditional public schools. However, in subsequent research, I also am a school finance scholar. and I do a lot of research on the connection between race and funding. And what I found in my research with Bruce Baker, who's an eminent school finance scholar now at Rutgers University, is that there's a great deal of research that indicates that it's much more difficult to provide for the educational needs of schools that have high concentrations of Black students. They tend to graduate at much lesser rates. And in my research specifically, what we find is that it would take even more resources to provide them with the opportunities that traditional public schools may have. And so because of that research, we became very, very concerned about charter schools. And in addition, you have to understand that charter schools also tend to be much smaller than traditional public schools. So therefore, we might have a situation where we're creating schools systematically that may not be able to meet the needs of the students that they're serving, and they have the added problem of being too small to take advantages of the economies of scale. So that's a major, major problem. And so in a brief that I wrote with Julie Mead of the University of Wisconsin for the National Education Policy Center, we were asked to actually create a model charter school statute which would balance the goals of equal educational opportunity and choice. And one of the ideas that we came up with was this idea of a rebuttable presumption of invalidity. And that is, if you had a school that was predominantly like racially isolated, then there was a presumption of invalidity, and that school would have to show through its educational programming how it would address it. It would not be alchemy. It would not say, they're going to show up and they'll come and they'll learn. Please explain how you will do it. And so it wasn't a case where we would say that they could never run. We wanted them to actually establish this. So that is sort of like one area that I've been looking into with respect to how to balance choice with other goals of equal educational opportunity, the idea being that charter should be a mechanism that could accomplish all of those goals, not one or the other. Now, the second issue that I've been looking at very recently is the issue of charter schools and student rights. Now, just very quickly, there was a case called, it's actually a Ninth Circuit case called Cavness versus Horizon Learning Center. And in that case, the Ninth Circuit found that charter schools were not state actors with respect to employment, teacher employment. And what was interesting about that case was that the court looked at Arizona, like a number of states, actually says that charter schools are public schools. So it seemed to follow that since the statute stated they're public schools, they were therefore would be required to follow public law and constitutional law. But what the Ninth Circuit found was that the language that there was actually a public school did not matter. What did matter was the relationship between the charter school and the statute, and also the charter school and the contract. And what the court found is that when one looked at the issue of employment, what they found was that there was no compulsion to actually act with respect to the Constitution. There was no compulsion to provide this teacher, and the facts of this case are really kind of funny. You had a boundary challenge teacher who really had inappropriate relationships with students. This person could have been on Oprah, you know. And so what happened there was that that teacher claimed that he should have received a name-clearing hearing under due process and was denied because the charter school said it was not a state actor. The court said, you're not a state actor, so therefore, teacher, you're out of luck. Now, why is that important? It's important for, even though this case is an employment case, I was actually privy to a discussion with some charter school lawyers in a conference where I had to talk about charter schools and civil rights. I was brought in to talk about this, and I was pointing out, well, since they state in the statute that they are, in their statutes that are public, that should follow that they have to follow civil rights and constitutional rights. Their response is, no, we don't have to. Have you read the Cavness case? And I'm like, well, that's an employment case. The key takeaway here is that if you look at the analysis in Cavness, if you apply it to students, it applies the same way. In the Ninth Circuit, in an article that I wrote, an article that I recently published, we noted that if you apply the same standard in the Ninth Circuit, there's only one state where it actually says that you actually have to follow constitutional rights of students. And this has important implications for Black students, especially Black males, who, as the statistics have shown over the years, are suspended and expelled at disproportionately high rates in traditional public schools, where they're required to provide due process. If you actually remove those protections, then if charter schools are not state actors, then private school law would apply. And that really does raise a great deal of concern. So that's the second issue that I've been really writing a great deal about, trying to publicize the need to address it. The final issue that I'm working on right now is a revisiting of the question of whether charter schools are indeed public under state constitutional law. When charter school, in the mid-1990s, there were a number of cases that looked at whether charter schools were public schools with respect to state constitutional provisions requiring that prohibited funding to private schools and also funding to schools that fell out of a uniform system of public schools. And in all those cases, it was found that charter schools were constitutional and were eligible for funding, in part because the statute said they were. They were public. And they were, and that they were seen as being under the exclusive control of the state as well as for systems purposes. But they never really addressed the question about the rights issue, because it does follow that, it seems to me that it follows that a public school may have to provide for the rights of their students. It seems to me that that is the case. But what the charter school attorneys are arguing is that they're not a public school, rather they're a private entity providing a public service. And this is a major concern because if you look at state constitutional law, there are a number of states with constitutional provisions that explicitly prohibit funding to private schools. So, so that is a concern, and that could really raise questions about their constitutionality. This coupled with the fact that a number of charter school advocates are arguing that they should not have to comply with state accountability measures as imposed by No Child Left Behind and by state accountability statutes. This is important because if you read some of the voucher cases, Judge Kaczynski mentioned the Bush versus Holmes case in Florida, where a voucher program was found to be unconstitutional under that state's constitution, because that's, among other things, vouchers did not have to comply with a state accountability system. So if you combine the refusal of providing student rights also with the excusing from state accountability systems, it may follow that charters are not only private schools, but they also may not fall within a system of uniform public schools. So this is an issue that I'm working on and developing, possibly for the Throw Symposium. So anyway, it's a quick whistle-stop tour through some of the legal issues around charter schools and privatization, and I thank you much for your time.
So I'm going to talk about the prison side of all of this now. And generally when we survey the debate on private prisons, you find two very strongly opposing factions. There are the rah-rah pro-private prison people who talk about the magic of the market and how that's going to make prisons deliver a better quality product at lower cost. And there are the very anti-private prison people who talk about, number one, losses of accountability and so on, but are also concerned about excessive cost-cutting incentives, how that's going to lead to more abuse of prisoners, and that there may not even be any cost savings at all, in addition to quality not going up. There aren't that many people who are in the middle. This is a very highly polarized debate. And based on my writings, I often get pegged as somebody who is one of the rah-rah private prison people. I actually have never taken a strong position in favor of private prisons in any of my writings, but so I suppose I'm less rabidly anti-private prison than the whole anti-private prison camp. So I suppose you can lump me on that side. My true belief is that if you look at the actual empirical studies on effectiveness, cost, and quality of public versus private prisons, you find that we actually know very little, that all of the research is very bad. Almost all the research is very bad. We know very little about cost. The reason is because public prisons and private prisons calculate cost in different ways. If you're a public prison, for example, your benefits administration and your lawyers probably are not in the Department of Corrections, they're in some other department. And so there are, you know, payroll, human resources, they're all in some other department. So there are a lot of costs of public incarceration. They're not borne by the Department of Corrections. So you can't just look at their budget. But at the same time, to figure out the cost of private prisons, you can't just look at the contract price paid to private prisons, because one of the costs of private prisons is, for example, monitoring them or catching escapees or something, and that's also borne by the public sector. So really, to say something serious about the cost, relative cost of public versus private prisons, you have to make a serious effort of trying to allocate costs of public versus private in actually a realistic way, thinking about what costs are and aren't borne by their respective departments. Almost nobody does this. The bigger scandal is, what about quality? It would seem obvious what you should do is look at the performance measures and measure the performance measures for the public and private sectors, and then you sort of see where you do better and where you do worse. Well, the scandal, I'm going to reveal it to you, is that there are almost no performance measures. There are virtually no performance measures. Actually, there are some prison researchers who have developed some interesting performance measures, and they're almost never used. So it is fair to say, well, you know, if you really believe in the magic of the market, why is it that we've found very mixed or no results? You know, to the extent that there are any sort of results of any validity, I would say that they don't tend to give a strong edge either to the public or private sector. I mean, this is contrary to what you would hear from the activists on both sides. If the market really is so magic, why doesn't it just hit you between the eyes just how stupendous the private sector is? Why would you have these kind of, it's basically a wash type results if the market is so magic? Now, reserving the question of whether the market is magic, I will just say that it's because the way we write contracts with private prisons does not in any way encourage quality. And the reason is because we do not compensate based on performance criteria, because whatever performance criteria there are virtually never used. And moreover, even if we did, we don't give private prisons flexibility to choose how they're going to operate. Because if you look at a private prison contract, a lot of it is just, we're going to take the whole big public prison rule book and we will incorporate it into the private contract. And so essentially, private contracting is going to be an exercise in who can do the best job of imitating a public prison, in which we also do not reward you for good performance. So, you know, it's not surprising that whatever the magic of the private market is, no one's using it here. Now, in 1993, there was a statute called the Government Performance and Results Act, which was supposed to strongly encourage the development of performance measures. And in a number of areas, it has not really lived up to its promise, because prisons are not the only area where the performance measures, effective ones, have just not been created. Now, what are the costs of this? Number one is just purely the accountability of private prisons. We want to be able to say in our debate, which works better, public or private prisons? Okay, we can't do that. Performance-based compensation. Britain is actually a leader. Just in the last couple years, they've started to experiment with performance-based compensation of prisons. The federal system, the Bureau of Prisons, had a demonstration project, the Taft Prison in California, where part of the compensation was based on performance measures. So that's an interesting thing, just recently got off the ground. There was a bill in Florida which, if it had passed, would have implemented some performance measures, but that failed, so that's not happening. So performance-based compensation, that's, we can't have that. That's a second cost of not having performance measures. Competitive neutrality, this is a closely related idea, that to really get the benefits of the public and the private sector, it would be nice to not necessarily privatize the whole system or 0% of the system, but to privatize part of the system and allow the public sector and private sector to bid against each other and compete to get a job. But to do that, you have to have proper ways of measuring their performance, or else it can be kind of smoke and mirrors. You can't do that. And finally, accountability just for the public sector. Even forget about privatization. Suppose you don't care about privatization, you think it's awful, we should never do it. You're in one of these states that actually bans prison privatization. We could still have in the public system, we could measure the performance of public prisons and give performance bonuses to public wardens. So anything that we could use to incentivize good private prisons, we can use to incentivize good public prisons. So this is why it's kind of a good idea to have performance measures, and it's kind of scandalous that we don't. Now, what could performance measures potentially involve? A number of people have come up with different views. There's one guy, Logan, he's a big private prisons scholar, and he has suggested some measures like the degree of security and safety and order and conditions and management and so on. And he doesn't really care so much about recidivism. So recidivism is not even one of the performance measures, but he justifies that by saying, I'm not a rehabilitationist, I'm a retributionist, so a retributivist. Of course, these are value judgments that you have to make. Are you going to be pursuing retribution, rehabilitation, some combination of those, or what else? There are some other people, Gerald Gaze, who is also a big criminologist, has come up with his own set of performance measures, part of which includes rehabilitation, recidivism, and in addition, various safety measures. The Florida bill, which failed, it had a little bit of both. It had violence and in-prison conditions, but it also had recidivism. Unfortunately, it also had some performance measures which were not performance measures at all, just outputs. How many people do you enroll in a rehabilitative program? Who cares whether it works? Just enroll more of them. So you have a worthless program and you enroll everybody, that increases your performance measure. So this shows some pitfalls. Number one, you have to get your values right, what you want to encourage. And number two, you want to be sure to actually pinpoint what you think is actually good performance and not some intermediate measure which might be somehow correlated with performance, because once you do that, people are going to start teaching to the test, that is trying to maximize the intermediate measure rather than maximizing the overall measure. So what are the problems with performance measures? You know, they're not all great. And I just mentioned one of them, which is a kind of, there's a myopia that once you have a performance measure, you can try and maximize that instead of the overall good. Also, having performance measures means you have to be able to accurately measure this stuff. That means you have to invest in strong independent monitors. For private prisons, it might require that you subject them to things like the Freedom of Information Act or something similar. In any event, prevent them from being secretive, but you also have to have good monitoring of the public prison. So you really have to invest in that because one of the other costs of performance measures is once you make compensation contingent on something, then of course the smart money, where does it go? Into trying to falsify the results. So number one, you can try and pursue the intermediate measure versus the overall good. Number two, you can just try and sort of fudge the numbers or falsify them or something like that, so somehow game the system. I should add, this is not solely a question about prisons. Performance measures could potentially be used in many areas. There are strong critiques of performance measures in many areas. For example, education. There's No Child Left Behind and other accountability type statutes. There are concerns about using, strongly numerical criteria to figure out how well a school is doing. I'm not a big fan of those sorts of numerical accountability measures in schooling. To the extent that we have government-run schools, I might be convinced to accept some numerical accountability as a second best, but I would be really concerned about that bleeding over into private school performance measurement. Similarly, there's a kind of numerical approach to environmental regulation, cost-benefit analysis, for example. And I've been very critical of the use of cost-benefit analysis in environmental regulation in some of my previous work. For example, you might bring in a comparative effectiveness worldview and rhetoric, which is out of place. Maybe there are some moral or fundamental legitimacy concerns. And I think that those concerns are very important in education and in environmental regulation. I actually am sympathetic in general to that concern, not so much for prisons. That is, I think that using performance measures to reward prisons actually is not morally problematic in my view. Either I think there's no legitimacy problem at all there, or to the extent that there is, it's sort of speculative how the performance measures actually impinge on that. My bottom line for prisons is bean counting is great, provided that you have the right beans, and so we should put the effort into figuring out what the right beans are. So, if performance measures are so great, why don't we have them already? So maybe some of you might be thinking, it's actually foot dragging on the part of the private prisons, because the private prisons maybe don't want to be rated based on their performance. And I think no. I don't think that's the reason. It's true that private prisons have no reason to care as such about whether they perform well. They also have no reason to oppose it. If I am a private prison, I'm going to say, I will do whatever you pay me to do. Just tell me what you're going to pay me to do, and I will do that thing. If you want to pay me for recidivism, which you hadn't been doing, for low recidivism, which you hadn't been doing before, I am perfectly happy to figure out what works and invest in that. If anything, I think the private sector has more flexibility to partner with other organizations that might have job training programs or other things like that. So I think the private sector just wants to say, tell me what beans you're counting and I will maximize those beans. I think the bigger problem is it's in the criminology profession as a whole. Even for measuring the quality of public prisons, criminologists have not been on the ball, and this is actually an advantage that privatization has had. It was the need to evaluate whether private prisons were a good idea in the first place that actually got people thinking about performance measures. So actually, privatization was the impetus for developing performance measures, which now can be used to improve the value of the public sector too. This is one of the benefits of privatization, that in reality, just on the ground, oftentimes the existence of that choice forces us to be more precise and to conceptualize what we think of as the good. And it can have systemic benefits of allowing competitive neutrality and churning of systems between the public and private sector, cross-fertilization of ideas. And so, my conclusion is that this is why we have not seen any stupendous results from private prisons, because there have so far been no incentives for rehabilitation or good performance generally, and also no flexibility. That is my idea for today on private prison reform.
Well, I'm going to follow Professor Terrell's lead and take the first question to the panel myself, and then I'll ask the panelists if they have questions for each other. But my first question is following up on Professor Royne's suggestion that maybe privatization is not about function, but is actually about budgeting issues and is a way of getting secured debt without going through the requirements that the law generally has for government to obtain secured debt. Professors Volokh and Professors Green, I wonder if you would comment on whether you see that dynamic in the areas of education and prisons, or do you think it is more about function, performance, as opposed to financing in those areas for the governments?
I've actually seen either that critique or something very much like it for private prisons. Now, I'm not a tax guy, so this is something I would like to know more about, but so far I've only been observing it from the sidelines, where people talk about if you're going to build a whole another prison and you're going to have to raise the money, and then you're going to have to issue bonds, and there's a requirement for voter approval of the bonds because of the huge indebtedness. But on the other hand, if a private prison company is just going to build a prison on spec and then try shopping around for some government that's going to send prisoners to fill the prison, then essentially the government is just paying rental rates for the prison, which already incorporates some kind of amortized value of that whole construction cost. And so that way, a government can increase the number of people that it incarcerates without having to pay this extra accountability cost of putting bond issues before the voters. So there's one way that I disagree with this critique, and another way that I agree with it. The way I'll disagree with it is this. There is a reason why we have a requirement of voter approval for bond issues, and that is precisely because indebtedness of the government is an important thing, and it has effects for future taxation and so on, and so that's why we want to have super special accountability for when the government indebts itself. Much like when I buy a house, then I'm going to have to give a lot of documentation about my finances to the mortgage lender, but not when I'm merely renting a house. And so it seems that if the government is essentially going to rent the prison, it's appropriate to not have voter approval of the bond issues, because those accountability concerns related to indebtedness simply don't exist, because you're just going to be renting your prison. So there is no long-term indebtedness issue there. One way that I do agree to an extent with the critique is just this broader thing, which is anything that makes it Anything that makes it cheaper to incarcerate people might increase the reach of the carceral state. And so if you believe that there is overcriminalization, and I do, and I think that overcriminalization is probably the biggest problem in kind of criminology. It's not a matter of privatization, it's not a matter of conditions, though those are important, but really it's a matter that we lock up too many people. Then we really need to be very iffy about anything that makes prisons cheaper or even more effective. Anything that makes prisons cheaper or more effective might make us want to lock up more people. So in that sense, it could be a call to let's make prisons maximally expensive and maximally ineffective, and that will make us less likely to lock people up. But you know, we laugh, and it's okay to laugh, but there's a point there. I just think that that is a bigger concern than about privatization. I mean, that would be a concern even about making public management more efficient, that it could potentially produce incentives to lock up more people. And so if you really want to take that concern seriously, then that's going to have effects on a lot more than privatization policy.
Okay, I'm trying to remember your question. It was about sort of like
Well, whether you see any evidence in the context of charter schools that government is moving to charter schools, outsourcing to private parties, in part to avoid the procedural requirements for taking on debt to build new schools or new facilities.
it's possible that they're trying to do that. The problem is that it doesn't make sense, because what the government is proposing to be done is that there's this creation of this sort of like alternate system of education. Say what you will about public education, it actually is relatively efficient in meeting its goals. And so so the danger that may happen is that the government is moving towards creating alternative systems in addition to the big system that it has. And we're talking not only public education, we're talking sort of like this quasi-public education, quasi-public education charter schools, and then also vouchers. And so what can happen is that you're actually much more inefficient. Just to give you an example of this, and I'm going to move to the vouchers on this one. Hank Levin of Teachers College, Columbia University, a noted economist, has done some research on what it would take to actually provide a voucher system that would actually provide, services comparable to that of a public school. And this is back in the mid-1990s. He estimated that it would cost about $2,500 more per student to do. Because you have to not only the education, but you have to function transportation interests. You also have to consider disability concerns. There are all these added costs that no one is thinking about. And so what I think where I've come on this is that I don't have a moral objection to this. I just don't think it's good money. Throwing good money after bad. And that what you really have to be thinking about doing is finding ways of improving the traditional public system, because that is actually probably the most effective, efficient way of meeting the needs of the most kids.
Yes, please.
I would never say that every one of these privatization deals is about hiding secured debt, because I don't think it's true. If it's a short-term contract, you're not secured debt. But there are a lot of these privatization deals under which your contractual obligation to rent exists is for a term of 70 years or 75 years, and there really isn't any difference there between renting and owning the asset, and therefore there isn't a difference between secured debt and the arrangement that we've got.
That's possibly then an issue for these long-term
That's
tollways,
exactly
whereas
right.
the prisons are much shorter contracts.
That's exactly right. And indeed, when I'm thinking about the termination for convenience thing, it doesn't make sense to have a termination for convenience provision unless you're dealing with a long-term contract. Because if you're dealing with a short-term contract, if you don't like the way the prison's being run or the school's being run or something like, you just don't renew it. But in these long-term contracts, you don't have that option. You're stuck for 70 years.
Before I follow up, do the panelists have any questions for each other, or? Well, then I'm going to ask a question based on my experience, what I saw in government. And the question is, when you privatize, a lot of times government does that in order to reduce its overhead. And so it lets employees, if not entire departments, go. And in effect is giving up its expertise in the area. And I believe everybody talked about the need to have effective performance criteria or just effective contracts to spell out what is required. But what I see is that government loses the ability to even draft a request for proposal because it no longer has people who have the expertise, who are functioning on a daily basis and know what the common problems are and what you want to try to contract about, to the probabilities you want to try to contract around. And so then they end up turning to outside parties who often are the contractors or potential contractors to give feedback on how to draft the RFP. And I wondered if you had any thoughts or on safeguards or how to address that issue. How does government write an effective contract if it has no expertise anymore in the areas that it's seeking to obtain services or goods?
In the case of charter schools, the flip response is to get the people who do have the expertise to write that. And this actually goes towards a bigger issue. Like in the early 2000s, I was writing about this very issue, about like how do you sort of monitor what private institutions, private entities want to do. And what we found in our research is that that public schools, that the public system tends to really be at a disadvantage when dealing with educational management organizations in terms of writing the charter, in terms of like creating performance mechanisms. And in part it's because they do feel that they are at a disadvantage. And so what we had suggested really in the first place, in the brief that we wrote for the National Education Policy Center, is that you actually, as part of your statute, you can actually identify, the school district could identify specific needs that it has, and then say that there are specific goals that we want to have established within their context, and then open up the RFP for private entities to then do it. And so in that way, the school district has identified its needs. It certainly feels much more comfortable at what it's looking for, and then it can then sort of look for people who are providing targeted ideas to meet those needs. So I think the thing is that they have to really do a much better job of assessing what those needs are, and then become that much wiser, really, about the contractual game. That is that a lot of what you will end up getting will be based upon what you actually say that you need up front. And so it's just more of a case of just being much more wise about doing it in the first place, so that, when there's a problem later on, they can say that these are the measures, this is what you agreed to.
I would think that there are three different types of maintaining capacity that you want to have, at least three, in a privatization context. One of them is, I alluded to the idea of cross-fertilization, that it could be that the private sector is good at doing certain things and the public sector is good at doing certain things, and competitive neutrality is nice because you would have each sector keeping the other honest, and you would always have the possibility of the same service churning between public and private sector and having cross-fertilization of ideas. This is something which people have argued for in prisons, in wastewater treatment facilities, in all sorts of things, and recently in the healthcare debate, all the talk about having a public option for health insurance was the idea that you should be able to choose between private health insurance carriers and a public one, and if you think that the private ones have some biases, you always have the public one as a fallback. So if you believe that this kind of competitive neutrality and cross-fertilization is important, then I think that means that you want to make sure that you've got at least some minimum public capacity to do the service. There's the other thing, which is if you're concerned about the sudden failure of your private contractor. So if you're concerned that the private military company is going to walk off the job, or if you're concerned that your private prison firm goes bankrupt or something like that, then you might want to be able to have someone who is going to be able to step in those sorts of disaster scenarios. And so that might be a reason to have public capacity on tap, or it might just be a reason to have another private provider who provides insurance for you, because like if you have catering for government lunches and all of a sudden the government lunch provider goes bankrupt, you don't need to have a government lunch provider. You can just go to you can just go to a competing private company. But sometimes you might want to have public capacity there. And then the final thing is, very importantly, you always want to have the public capacity to be able to decide whether to privatize and to be able to monitor the contracts and to be able to write the proper RFPs and things like that. And that's something where privatization really does increase the duty of government to invest a lot in that kind of contractual oversight and monitoring.
Yeah, I was just going to add that you have to have the capacity to monitor, or because if you don't have the capacity to monitor, you know, anything can happen. There are no controls whatsoever. There are some contexts where perhaps the public would be a decent monitor. For roads, perhaps, the public could be a somewhat decent monitor because they will notice if the roads aren't paved, if they're not getting plowed and things like that. But there are many government functions for which the public is a terrible monitor, and so it's an absolutely false economy for government entities to be doing what you're describing, which is to get rid of the monitors.
Before I follow up, are there any questions from the audience? Yes. No, I just see now that there's a microphone
Yeah, with
back there, so
microphones
if you
back
want to
there.
go to the microphone, and there was someone standing there, so I'll take your question second if you don't mind. Go ahead, sir. Just go to the microphone so everyone can hear. Sorry.
John Michaels, UCLA Law School. In addition to the theme of kind of using privatization as a backdoor secured debt approach, there's also the question of labor arbitrage, which is one of the questions that arise of, even if privatization is cheaper, is it because salaries are lower, there's no pensions, lower benefits, and also the potential, and not the potential, the fact that many government employees have the equivalent of civil service tenure. And so it's quicker to fire people, quicker to hire people and promote them. There's more flexibility there. Now, Sasha alluded to the fact that privatization is giving tips not only to private organizations about how to better perform, but also influencing the public sector. And I agree with that, but I think there's also a negative side to the kind of importation of market principles, which is precisely these notions that core elements of public labor policy have been changed. It might be particularly relevant in Preston's case with maybe how it's influencing the tenure debate within even the public school systems. But I just wanted to hear your thoughts or reactions about the kind of potential either erosion or reform, however you want to normatively put it, of the kind of the way public labor might respond.
Well, I think that your last sentence, erosion or reform, is exactly the question. I don't think that there's any dispute over the fact that when functions are privatized, it does change labor relations, and you will find some people who think that's wonderful and some people who think that's terrible, and it depends on, to some extent, what you think about public labor unions. And I don't have any strong priors on that. But I think you're absolutely right that this is an issue for some of these transactions.
I should mention John Michaels is a big contributor to the literature on this question, so I recommend to you all everything that he has written. But this is something that I've read in a lot of your work, and the thing is that I think that you are more likely to see the move from a public labor regime to a private labor regime, number one, as something which is slightly illegitimate, and number two, as something which is slightly smuggled in and is not really part of the explicit case for privatization, but is more a side effect which is possibly being allowed to drive the system. So I think I have at least slight disagreements with both of those. I think that far from being something that's not really part of the debate, I think that's actually a major part of the debate, that a lot of the explicit grounds, a lot of the explicit argumentation for privatization is precisely that we can escape public sector labor unions and civil service protections and tenure and high public sector wages and so on, and go to the lower wage, lower protection, lower unionization private sector. And so I don't think that's being smuggled in. I think that that is actually an explicit reason that many people use to privatize. And I would add that I think it's a valid reason to privatize. I am willing to make my peace with civil service protection and tenure and all that sort of thing, because I think that when you have government employment, to the extent you have government employment, there's a big danger of patronage in government employment, and civil service protection is necessary to protect government employment against that kind of illegitimate use. I think that actually makes it much more important to limit public employment as much as possible and to move things from this highly protected public sector into the lower protected private sector. I think that is, I think that's legitimate, and moreover, I think that that is one of the very valid arguments in favor of all sorts of privatizations, which is it's actually a good idea to limit public employment and civil service protection as much as possible.
In the case of education, yes, I mean, if you look at the Wisconsin battles, the battles across the nation, that the tenure issues relating to charter schools are huge, and that in a number of states have done away with tenure in their charter school legislation. Now, you know, if there is any evidence that that would improve education, I would be completely supportive of it. I do have my doubts. The time will tell if that is indeed the case. The big problem is that, I mean, research indicates that you really do have to be in a job for a little while in order to be good at it. And the concern is that if you start going more towards an an at-will approach to education, it raises the question of how long will people stay in the field? And how long will they stay in long enough to develop the skills to actually be good teachers? And so that is sort of like, it's an ongoing issue, but that's certainly something that we'll have to see, you know, down the road. The other concern is that public schools have a hard time attracting people into the teaching profession as it is. I always joke, when I teach education law, I always say, hey, I teach education law, and I always have like a whole lot of, I'm seeing more and more Teach for America students in my classes. And they say, oh, you know, Professor Green, my mother was a teacher, my father was a principal, I just love education. So why aren't you in it? It doesn't pay enough. I want to do it, but I know that law will pay the bills, and it will still pay the bills. Don't drop out of law now, students. But these are very real concerns that we have about education, and so you don't want to create these perverse disincentives where you have even a greater problem attracting people into the profession and enabling them to stay.
I harmonize those concerns by teaching law.
Sir, question?
Yes, thank you. This question is mostly for Professor Green, but I'd appreciate the input of any of the panelists. You were talking about the maneuverings between being labeled as public versus being labeled as private in order to avoid, for instance, state education regulations. What do you see about that in terms of maneuvering around civil rights obligations, either statutory, like the Individuals with Disabilities in Education Act, or constitutional civil rights obligations in terms of this public-private labeling?
Yeah, because of the time element, I didn't really go into much detail about that. But a lot of my research has actually examined, really in the federal context, how charter schools are trying to get around the issue of public requirements under federal law. And let me just provide a greater gloss on this conference that I attended. I was at a National Charter Schools Attorneys Conference in San Diego. And what I remember the best about was the weather. The discussions that I had with the attorneys were somewhat disconcerting. But they were saying, because the question that they posed to me was like, well, do charter schools have to comply with civil rights and constitutional law? And I'm like, well, yeah, the statutes say that they're public. And they kept saying, we do not have to do this. And we started talking about school desegregation provisions, parents involved, all of these concerns, and they were saying, we don't have to do this. And so that's when I really began to examine this question more closely, and then it resulted in a series of publications, one of them addressing the question of what happens if the employment approach gets applied to students. And so that's a major concern that I had raised. And anecdotally, I think what is happening is that, especially with respect to student discipline codes, the charters are doing while they are able to kind of target the issue with respect to teachers, because it's much easier to do, they're in sotto voce ways, they're sort of like, in various places doing the same thing with respect to students. You see, and in fact, I should say that my article got picked up by the Washington Post in one of the education blogs, and I have to say that right afterward, you saw more and more stories come out nationally about evidence where students are being expelled or suspended at much higher rates than charters, and evidence with respect to the individuals with disabilities. And so, you're seeing this happening in various places, with the goal being that I think that they'll try to accomplish this under the cover of darkness. And so it's really important for policymakers, attorneys, scholars in the field to at least put this out there and to have an honest discussion about it. There may be reasons why people may decide that it's okay, or parents may decide that it's okay to treat a charter school the way they would treat a voucher. But they should at least have that honest discussion first before they do it.
There's actually a really interesting recent NLRB decision, a recent NLRB decision about how a Chicago charter school, they thought, because they were a public school, that they would be part of the Illinois Educational Public Sector Union. There's their hiring decisions. It turns out that the NLRB believes differently, that the NLRA, which is mostly the federal body of labor law, which is mostly for private employers, applies to all employers except for states and their instrumentalities, or states and their political subdivisions. And so the NLRB said, well, a charter school is not a state, and it's not a political subdivision of a state, because it's not created by the state, and its officers are not removable by the state. So therefore, even though a public school is subject to the Illinois Public Sector Employees Labor Relations Board, a charter school is subject to the NLRB, like all private employers. And this is the same for prisons, as a private prison is going to be subject to the NLRB, whereas a public prison, probably whatever sort of state public sector labor relations board, which is probably more pro-employee. And every individual statute has its own coverage provisions. So, for example, the ADA applies to states and their instrumentalities. And so it turns out that the ADA, Title II of the ADA. So Title II of the ADA applies to public prisons, but not to private prisons. On the other hand, you have other statutes like RLUIPA on religious liberties in prisons, and that applies to whoever is a state actor. And so private prisons are state actors, and so RLUIPA applies, and all the other constitutional rights do apply because of state action. So actually every individual civil rights type law potentially has different coverage provisions. So by privatizing, you might find unexpectedly that, oh, you're still subject to RLUIPA, but you're not subject to the state labor relations thing, and you're not subject to Title II of the ADA anymore. And so what that means is people who are privatizing need to be very intelligent about their contracting, and if you are concerned about Title II of the ADA applying, you should write that into the contract, that those things will independently apply as a matter of the contract.
Ladies and gentlemen, we started a little bit late, so we ran a little bit late, but we are eating into your lunchtime, so we are going to stop right here. Please join me in thanking our panelists.